Hello and welcome. So here we are 6 months into 2016, and what busy, exciting and satisfying month they have been. We started 2016 with one of our clients receiving 41,208 euros that they had earlier been awarded, and it just hasn't stopped since. As we mentioned previously, last year the Supreme Court agreed for the first time ever to accept the study of a case relating to timeshare contracts. This was the case of a CLA client, and the justice wanted to rule in our client's favor.
Since then, the Supreme Court has continued to rule in favor of our clients on a whole range of issues until very recently we achieved the 15th ruling. Some fundamental principles have in the process been converted into jurisprudence, which is to say they have become the required interpretation of the law. The repercussions of this ruling have been felt through other lower courts. They have followed the Supreme Court in the content of their ruling, but the clarity of direction has had much greater impact. On the morning of the 14th of April, we attended court with the Nilsson family for their hearing. We had barely made it back to the office that afternoon when we received the judge ruling. On the 27th of May, the exact same thing happened again with the Inden family. Prior to the Supreme Court rulings, this could have been unthinkable. We really have been making legal history in the first half of 2016. On the subject of history, the case which resulted in the very first Supreme Court ruling, one of our Norwegian clients, Mrs. Greensbo, finally received the money she was awarded, more than 40,000 euro. This was the case which paved the way for all the others, and the administrative process for the refund making its way down the course took a little time. However, her confidence and patience were rewarded in early May. That was the start of an extraordinary month for CLA in which we received 2 Supreme Court sentences, the award of our largest claim to date of 189,000 euros, one of the fastest decisions we have ever experienced, and decisions reached again a whole range of timeshare companies and resorts. This was a direct result of those Supreme Court rulings, which is why we refer to them so often. It is impossible to overstate their effect. These rulings have ended debate. Floating weeks and point systems are illegal. Paying any money to anyone in the cooling off period is illegal, and contracts which exceed 50 years duration are illegal. As this extraordinary 7-month closest CLA has now achieved 15 Supreme Court rulings, and more than 1.3 million euro of sentences in favor of our clients.
We have more than 830 cases live and in court, including more than 100 at the Supreme Court, ready to make more history. We are winning sentences at the rate of more than 1 per week and accelerating. However astonishing this last 6 months has been, we cannot wait for the next 6 months. For the most up-to-date news, visit our website, CanarianLegalAlliance.com. Thank you very much. See you next time.